Welcome to the Planning Commission public hearing for Wednesday, August 20th, 2025. All hearings tonight are duly advertised, and the certificate of publication is part of the record for each hearing. Citizens are invited to provide comments on any or all of the hearings after each presentation has concluded. Each of the hearings will have a separate comment period followed by a brief following the brief presentation. Anyone that's here in person who wishes to speak must sign up on the sign-in sheet located at the door, and I think they're color-coded as to the text amendment that you would like to speak on as you enter the door. My name is Tamara Blake-Wallace, and I am the Deputy Director of Planning, and I will now turn the meeting over to our chairman.
Good evening. Welcome to the Calvert County Planning Commission public hearing. I'm John Toohey, Chair. I'm going to take attendance to determine our quorum. Commissioner Burry?
Here.
Commissioner Freeland?
Here.
Commissioner Gadway?
Here.
Commissioner Kernan?
Here.
Commissioner McQueen?
Here.
And Commissioner Weems?
Here.
We have full attendance and we have a quorum, so we are therefore called to order. If you'll all join me in the Pledge of Allegiance, please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That brings us to item 3 tonight, presentation by staffs. And item 3A is the zoning map amendment, MA 2501.
Okay. Good evening, Commissioners.
Good evening, Mr. Hager.
I am Will Hager, Planner 3 with the Department of Planning and Zoning. And before we get into the presentation slides for zoning amendment 25-1, I'd just like to make a few opening comments. And that is that this public hearing has been duly advertised. A sign giving notice of the public hearing was posted on the subject property, and legal notice was mailed to all adjoining property owners, and we received no comments, no written comments in regard to either the map amendment or any of the text amendments that are the subject of tonight's public hearing. So with that, we'll begin the presentation for zoning map amendment 25-1. And we received this zoning map amendment application in March of this year. This material was presented at an informational work session with the Planning Commission back in June as well. The properties subject to this zoning map amendment application include 136 East Chesapeake Beach Road and 150 East Chesapeake Beach Road, located at the intersection of MD 778 and MD 260, directly adjacent and north of Owings Town Center. The existing zoning of the property at 136 East Chesapeake Beach Road is rural commercial, and the existing zoning of the property at 150 East Chesapeake Beach Road is rural neighborhood district. The existing uses at 136 East Chesapeake Beach Road is an automobile filling station, and the existing use at 150 East Chesapeake Beach Road is a single-family residential dwelling. The proposed zoning for the subject properties in this application is Town Center Core District for both parcels. The Owings Town Center zoning ordinance describes the core district as the intent within this district is to allow for a variety of complementary uses appropriate to the scale and traffic volume of regional thoroughfare and adjusted to the village scale of the Owings area and to promote and sustain commercial development. The proposed use of the property is an enhancement to the existing automobile filling station at 136 East Chesapeake Beach Road and expanded onto 150 East Chesapeake Beach Road. The automobile filling station is not a permitted use in the rural commercial district, making the existing filling station a non-conforming use. And if the rezoning request is approved, the proposed development would be in conformance with the requirements, regulations, and conditions set forth in the Calvert County zoning ordinance, which permits automobile filling stations as a conditional use in the Owings Town Center core subdistrict. On this slide, we're looking at the current zoning of the area around Owings Town Center. The two parcels circled in the middle are the subject properties. And on this slide, we're looking at what the zoning in the same area would look like if this zoning map amendment were to be approved. On this slide, you can see the delineation of the subdistricts within Owings Town Center as they exist today. Those subdistricts include the core district, village district, and the edge district. And on this slide, we're looking at the future land use map of the Owings area from the comprehensive plan. And in the comprehensive plan, as we can see on this map, the Owings Town Center boundary is proposed to be expanded to include additional properties north of Maryland 260 and east of Maryland 778. The subject properties are included within this expansion area. The proposed rezoning would enable the expansion and renovation of the existing automobile filling station. The applicant proposes to demo the existing gas station and single-family detached dwelling and redevelop the subject property with a new, modern, and better designed facility. The proposed renovation would enable the installation of modern and improved landscaping, lighting, and stormwater management facilities, an upgraded septic system, better on-site circulation, safer entrances, and other aesthetic improvements. On this slide, we have an image of the elevation drawing of the proposed redevelopment included in the application package. And on this slide, we have an image of the concept plan of the proposed development. The subject property is a focal point of existing commercial activity in Owings Town Center. As depicted in the comprehensive plan, this is the only major intersection included within both the current and future Owings Town Center boundaries. And Maryland State Highway Administration traffic counts from 2023 indicate an average daily traffic volume of 7,045 vehicles per day along MD 260 as compared to 7,971 in 2013. The applicant, on this slide and the following slide, we'll be discussing the applicant's justification for the rezoning. The current rural commercial zoning of 136 East Chesapeake Beach Road reflects the historic use of the property, which has existed since before the county's town center concept. The existing primary structure was constructed in 1970. Changing the zoning designation of the subject property to town center core would support the redevelopment of the existing automobile filling station and is consistent with the goals and intentions of the comprehensive plan. Although the existing use of the 150 East Chesapeake Beach Road property is residential, the appropriate zoning of the property should have been considered in the context of the surrounding properties and the future land use to conform with the comprehensive plan rather than placing it in a holding zone which is not reflected with the plan's intent for the surrounding properties. By designating the subject property in the rural commercial and rural neighborhood district zones during the comprehensive rezoning, the existing facts were not considered. The actual character and use of the property, as well as the property's location in an area designated for future development, is more consistent with the town center core designation. Reasonably foreseeable trends contemplated by the comprehensive plan and supported by the existing facts and nature of the subject property were not considered. and retaining the rural commercial zoning for the 136 East Chesapeake Beach Road property and rezoning the 150 East Chesapeake Beach Road property to rural neighborhood district was a mistake of fact because the rural commercial and rural neighborhood district zoning designations inhibit the type of development envisioned in the county's comprehensive plan. So, before we move forward with the public hearing, we received some questions in advance from Commissioner Burry on the subject of this map amendment, and if the commissioners don't mind, I'd like to respond to those
Thanks.
questions.
Please do, sir.
So the first question is, would the Planning Commission approval of the developer's proposed zoning change on the basis of Owings' current designation as a town center interfere with or prejudice a subsequent Planning Commission recommendation for removing Owings' town center status in the future? No. Planning Commission approval of the proposed zoning change would not interfere or prejudice a subsequent recommendation on the future status of Owings Town Center. The commissioners may agree that Owings Town Center is the most appropriate zoning for the subject parcels at this time and still recommend for the removal of Owings Town Center status at a later date. The next question is, does Planning Commission approval of the zoning ordinance change hinge on whether we think upgrading this particular service station would be a great idea based on the developer's arguments that these upgrades would not only aesthetically improve the Owings Town Center area, but will also enable the installation of modern and improved landscaping and lighting, an upgraded septic system, better on-site circulation, and safer entrances, promoting better general vehicular and pedestrian safety in the area? Or does our decision depend instead on a Planning Commission determination of whether or not Planning and Zoning made a mistake in the existing zoning classifications, regardless of the amenities the upgrades would provide? The commissioners may grant a map amendment based upon a finding that there was a substantial change in the character of the neighborhood where the property is located, or that there was a mistake in the existing zoning district classification, and that the proposed change in zoning district classification would be more desirable in terms of the objectives of the comprehensive plan. The application may be denied if the proposed amendment and possible resulting development would not be compatible with neighboring land uses. The applicant's arguments in regards to the benefits to upgrading the automobile filling station can be considered in regard to whether the proposed change in zoning district classification would be more desirable in terms of the objectives of the comprehensive plan. Next question. What is the Planning and Zoning Department's current position on whether a mistake was made in the existing zoning classifications? The department's policy during the update to the Calvert County zoning ordinance was that the expansions to the town centers called for in the comprehensive plan would be implemented during the updates to the town center master plans and zoning ordinances. Because of this, the subject parcels which are included in the town center, Owings Town Center expansion area called for in the comprehensive plan were not considered for town center zoning during the update to the Calvert County zoning ordinance and zoning map. Under the prior zoning, the parcel at 150 East Chesapeake Beach Road was split between rural commercial and employment center, and the parcel at 136 East Chesapeake Beach Road was zoned rural commercial. During the comprehensive rezoning, the parcel at the 150 address was zoned entirely rural commercial to remove the split zoning, and the parcel at the 136 address was zoned rural neighborhood district to reflect its current development and use as a single-family residential dwelling. This was consistent with how other comparable properties were zoned throughout the county during the comprehensive rezoning process. The subject properties were not looked at or treated differently due to being included within the Owings Town Center expansion area.
Hey, Will, if I can summarize then, so the Planning and Zoning Department's position is that a mistake was not made, correct?
We're gonna wrap that up.
Sorry.
We're getting there. So whether the current zoning of the subject properties should be considered a mistake is really dependent on whether or not the commissioners believe the policies and reasoning that resulted in the current zoning of the subject properties was the most appropriate for those properties. But on the subject of whether or not a mistake has been made, I believe Jason has some additional comments he'd like to make.
Jason Brinkler, Director of Planning and Zoning. I will stop short of saying that Planning and Zoning believes it was a mistake, but it's my understanding the applicant did let Planning and Zoning know about approximately a year and a half ago that they were interested in this expansion. There was no legal reason why we couldn't have considered that when we went through the comprehensive rezoning, and that was a policy decision, not meant to throw the previous director under the bus, but that the director made. I think comprehensively that was a good policy decision. Whether we could have looked at this particular situation because we knew that the applicant, or representatives of the applicant had reached out to our department and had let it be known that they had interest in doing this. And I believe we told them at that time to wait.
Okay.
That could be seen as a mistake.
Okay.
Thank you.
Okay, so I believe with that, I believe staff would request that the Planning Commission hold the public hearing, close the record, and make one of the following recommendations to the Board of County Commissioners.
Mr. President, question. If we have questions or comments ourselves, should we hold off until after public comment or before, or does it matter?
If I could. When it comes to the public hearing, it's section 2.202 of the bylaws lays out for each item. So for each text amendment, we have the testimony of the agencies in relation to the item, questions by the Planning Commission to staff and/or agencies, then presentation by applicant where applicable. So if there's an individual applicant, this is where they would get to come in and basically advocate for themselves. Further testimony from the applicant if it's applicable. Concluding comments of staff, so they get the last. Then it's concluding questions by the Planning Commission after everyone else has testified, and then public comment is at the very end. So basically the public should get the last call before we go into the vote.
Okay.
Thank you. With that said, Will, back on slide 5 and 7. 5 is the map of what it would be if this was approved. 7 is a map of what it would be if the comprehensive plan is approved. Am I correct?
What we're looking at.
That includes the town center expansion.
Yeah, this is a map of the future this is the future land use map from the comprehensive plan. So this includes the proposed Owings Town Center expansion area in the comprehensive plan.
Okay, so that would be a yes. And hypothetically, when would that go into effect? If it were to go through the process and be approved,
Well,
roughly?
that's a difficult question to answer, because
Jason might have an answer though.
Jason Brinkley, Director of Planning and Zoning. The plan at the moment is Owings would be the next town center that we look at. I would say that process, because there's a public input and everything, that determination is probably a year to 13 months out before an actual finalization would be made as far as that chapter would be. So approximately a year from now.
So it's my understanding that if it would be approved, if the comprehensive plan would be approved, then tonight's discussion would be moot. Tonight's discussion or vote would be moot. The only difference is a year later, give or take. Because it's gonna, at that point, that property is inclusive in the comprehensive plan. If this were to be approved and the comprehensive plan were to be rejected, it would be very similar to the situation where we could be argued now, where you've got a small segment of town center on the opposite side, not contiguous with other town center. That's my only concern.
I think during that approximately 1 year timeline, as public input and everything gets, feathered out and back before this body several times, what the ultimate future land use map or changes to the comprehensive plan needs to look like, it may be different than what is in front of you. It may be less. It may be along the lines of what you're saying, Commissioner. But that's to be feathered out over the next year.
Understood. Thank you.
Thank you.
One of the interesting things is Planning and Zoning Department went out to people around Owings with a questionnaire about the future master plan. Is that you included a question about whether Owings should continue to be a town center or not. And I think this tees up a discussion, especially with the recent Board of County Commissioners downzoning within town centers, about whether the town center status for Owings is in fact viable, given what the comprehensive plan language vision for town centers ought to be. How much future growth in infrastructure can Owings really support? So I think that's a future debate that is worth having with full public participation. What I'm worried about is any precedent that we might set here that would predetermine or affect that debate. So, for instance, if we go ahead and grant the zoning changes for these two particular properties, there are several other properties within the exposed expansion area that could also be submitted for a rezoning decision in the future, or under the proposed expansion of the town centers. And my worry is the potential development across 260 of either large commercial or large residential developments that would pour more traffic onto 260 with one or more future entrances and exits onto 260, which may require another traffic light. These are my concerns about the potential future of Owings. So I want to make sure that what we decide tonight is purely on the merits of whether the gas station ought to go there or not, based on a mistake that P&Z made. And does not prejudice any future land use decisions in the Owings proposed expansion area. Let me ask one other additional question. Is it possible to maintain the current residential zoning of the house and instead redevelop the property based on some of the vacant land on that same parcel north of the existing site, so that we are only obliged to rezone one property from rural commercial to town center? And that's probably a question for the developer about how practical it is.
Yeah, I was going to suggest that.
Another question I have, and this could also be a question for the developer. Instead of asking for it to be moved to town center, which there is no town center core on that side of 260, why wasn't it requested that the adjacent property in question, where the residential is, was not changed to R&D, which I believe is exactly what the automobile filling station currently is?
You mean rural commercial?
Yeah, rural commercial.
Yeah, rural commercial, sorry.
So the automobile filling station is a non-conforming use in the rural commercial zone.
Mhm.
So if the neighboring property were
Okay.
to be rural commercial, that would hinder that type of development.
Is a filling station a conditional use under R&D?
In the Owings core?
Uh,
Yeah, I believe it's a conditional use wherever it's permitted, I believe, just based off of memory.
No, the question is whether a filling station under rural commercial district is a conditional
No,
use.
it's no, the only, under our current zoning ordinance, automobile filling stations are only permitted in town centers.
Okay. Is the current filling station grandfathered because it's a pre-existing use and they're therefore not subject to the change in the zoning ordinance.
Right, it's a non-conforming use, which
Right.
fits that
Yeah,
description.
and so the station doesn't need to be dismantled. It can continue in current form, right?
But expanding onto, it would hinder the potential expansion that they're looking for.
Right.
Well, how long has a fueling station been on that site?
I believe that according to ESTAT, that original primary structure was built in 1970.
Do we know what existed on that lot before that?
I'm not aware of that information.
Thank you.
Are there zoning classifications that would permit the expansion onto the neighboring residential property that are not town center core?
Not under our current zoning ordinance.
Okay. Yeah, my concern is the precedent of expanding town center core across 260. It's something that I think the county has been wary of doing, is expanding town centers across major thoroughfares. That was certainly one of the debates when we looked at expanding Huntingtown several years ago. So that's one of my concerns. The gas station, even as when it expands, is probably not going to draw a huge amount more traffic than it currently does, somewhat. So I'm not as concerned about traffic. What I am concerned is the precedent for other properties on that side of 260.
260 in that area is a two-lane road?
Three,
Single.
I believe so.
And they're turning there.
Turn lane at the light at 260, at 2, I mean, 2 4, 2.
Okay.
At 2.
Has there been any remodels of the automobile filling station since 1970?
That again might be a better question for the applicant, but I don't remember that being mentioned in the application package.
Would there be anything prohibiting a remodel? Because they're currently grandfathered in as non-compliant. If nothing were to change today and wait for another year for it to change, or hypothetically change under the comprehensive plan, obviously if they were to remodel anything existing on the existing property and not go on to the adjacent property, correct me if I'm wrong, I don't think there would be anything forbidding them from submitting something for a remodel.
There are limits on how much you can expand for non-conforming uses and non-conforming structures.
50%, I think, is the
Yeah.
figure, right?
Mhm.
Yeah.
Okay. But it would be plausible.
There would be some site constraints.
Right.
Yeah, as I was looking at this site, the other part of that existing property gets very hilly, very dense very quickly, and would be a huge, substantial increase in expense with moving land. I don't know if its engineering is possible, but it certainly would be much more difficult than what they're proposing. My worry about deferring this decision until the Owings master plan gets passed or not is that if the county decides to strip the town center designation from Owings completely, then that really negates any hope of the expansion of the gas station at all.
Or it could be reapplied for.
Yeah, that-
With knowing that the town center was not going to be around it at that point.
I'm not sure there's a zoning classification.
No,
Absent the
there
town
is
center,
not.
I don't think there's a zoning classification that
center
could
can't
be
be there.
made
Yeah.
Right.
that would permit the gas station. Is that right?
Yeah, so
Yes.
the only place where automobile filling stations are currently permitted in our zoning ordinance are town centers.
Okay.
And if it's not a town center, it can't be there.
Jason Brinkley, once
Okay.
again, Director of Planning and Zoning. I don't want to go too far down the hypothetical
Yeah.
road, but if Owings was decided not to be a town center. I think the approach would be to look at the uses there now, not to create a bunch of non-conforming uses, but to create a different district that's not quite a town center, but something more akin to a rural commercial, but maybe not rural commercial. So I think we would be looking at the uses that are in place at that time and having that discussion with the Planning Commission about
Yeah.
how that needs to look in order to not create a bunch of non-conforming uses, but stop short of an actual town center.
I think based on everything I've heard that I'm inclined to support the recommendation for the rezoning. I think you've relieved some of my concerns about what the adjacent properties might look like. That's personally where I am. I don't know where anybody else is.
Thank you, David.
If you want, the applicant can now speak.
Please.
Good evening.
Good evening, gentlemen.
Is this on?
Yes, you can speak into it.
Thanks, Sarah.
If you give your name before you speak, please.
Yes, ma'am, of course. Good evening, Mr. Chairman, members of the Planning Commission. For the record, my name is Matthew Tedesco. I'm a land use and zoning attorney with offices in Greenbelt, here on behalf of the Wills Group, care of Dash Inn Food Store Incorporated. With me this evening, we have Mr. Mark Ferguson, who is with Site Design, Inc. He's an expert land planner on behalf of the applicant as well. And also in the audience, and if needed, we have our traffic engineer, Mr. Mike Lenhart, from Lenhart Traffic and Consulting. And from the Wills Group, care of Dash Inn Food Store, Inc., we have Mr. Tony Williams in the room as well. First and foremost, I really enjoyed the debate between the planning commissioners and staff. I want to thank your staff, in particular, Mr. Brinkley, Ms. O'Shea, and Mr. Hager. They have been immensely responsive, professional, and courteous to myself, my staff, and the applicant. As Mr. Brinkley indicated, we have really been at this for a very long time. Although this application was filed in March of this year, it dates back more than 2 years ago. In full disclosure, this property and this project was originally handled by my partner, Dan Lynch, who unfortunately passed away 2 years ago, November 2023. Even before that, there was efforts and meetings with the former planning director. I think Mr. Brinkley acknowledged that, as well as other staff members that date back more than 2 to 3 years. I got involved in 2003, the end of 2003 into 2004, and at that, before Mr. Brinkley was raised up with respect to his position, I would say. We met with the then planning director and had numerous meetings with staff. And all of the things that the Planning Commission has been debating here and thinking about, I think, since this work session back in June, are things that we vetted more than 2 years ago. And I want to thank Mr. Brinkley for acknowledging that this evening publicly, which means lends credibility to my indication of it. But I do want to thank you for that, Jason, for acknowledging that. With those meetings, we had a lot of discussion on what needs to happen, what should happen, in particular with that intersection of 260 and 778. It was actually at the recommendation of staff to seek this zoning map amendment. We went through various different iterations of what needed to happen, what should happen. All the questions that Commissioner, you asked today, well, are there other zones? How do we expand a non-conforming use? Because that property is handcuffed, I would say, and the current use, and Mr. Williams, who is here, can testify to it if needed, but we are really handcuffed. It is old, it is outdated, it's served its useful life, and it needs a refreshing. It needs to be modernized. It needs to be modernized with appropriate lighting, appropriate landscaping, held to the standard that not only the county demands, but town centers demand, that we see in other town centers throughout the county. I I don't want to say that Owings Town Center has been neglected, but it hasn't implemented the comprehensive plans, visions, goals, and policies. We sat down with your staff to figure out how do we at least do that on a one property case-by-case basis. And I can certainly appreciate the commissioner's concern about any type of precedent. I do not believe this case will set any precedent other than the precedent that the county is committed to implementing its comprehensive plan. And that's solely the reason why we sit before you requesting that. We did provide a very thorough statement of justification. It's in your backup. I don't want to go through it line by line, but I think with Mr. Brinkley's acknowledgement this evening, with the facts that are before you, it's evident that a mistake occurred when the comprehensive rezoning was done. It's all been acknowledged. This really gives us a tool for this property alone to not only implement the comprehensive plan and its future land use map, which is on the page there. And I'm not here to debate whether the town center future land use map and its recommendations as adopted and recommended by this body and ultimately by the Board of County Commissioners will change in the future, whether it's a year from now or 13 months from now. It may or may not. What we do have is the adopted comprehensive plan with this adopted future land use map. We have an old outdated site from 1970. We can't do anything with it. We can't expand it. We could put a Band-Aid on it, but to be fully disclosure, we've had the adjacent property, the residential use property, under contract now for 2 years. Those property owners are in here and desperately hoping for your support as well. That gives us the flexibility to expand the development, to modernize it with updated septic, updated landscaping, updated lighting,
Stormwater management.
better stormwater management, and better safety and circulation on-site and off-site. If anybody is familiar with that site, it is extraordinarily tight, extraordinarily tight. We just don't have the flexibility to go north or east, I would say, without this rezoning. And with that, I think I'll start becoming repetitive, but I would just simply say retaining the property in the RC and RND zones was a mistake because those zoning designations inhibit the type of development envisioned in the comprehensive plan and the future land use map that's on your screen. There is a clear mistake in the property's current zoning classification as confirmed by the future land use map, as confirmed this evening by Mr. Brinkley, and the uses plan's recommendation that the property be placed in the town center zone. So I do just want to also highlight a couple of things. We all are well aware of the cards that went out. I got one for the Huntingtown Town Center update. Neighbors got one for the Owings. We are 100% committed and desirous to participate into that process. We want to ensure that by tipping this first domino for this redevelopment of this property, regardless of what ultimately happens with the town center, it sets a standard for the remaining portions of the town center, even if it doesn't retain its town center designation. And so working with staff to do that now is beneficial. It will be a catalyst for the pending town center update, we believe. It will provide certainty for the private investment that's already been made. As I mentioned, my client has had the adjacent property, the R&D zone property, which is made up of the single-family detached home, under contract, I think, for the better part of a year and a half. We have extended it graciously. The property owner has been willing to extend it, but that's not going to last forever. And if that goes away, we will become even more handcuffed. So we do not necessarily want to wait and cannot wait. We were put on hold, I would say, for more than a year because of the zoning ordinance rewrite. There was a moratorium on applications like this. We couldn't even file it when we wanted to 2 years ago. And then again, last year when I got involved, we were literally just waiting for the zoning update to occur. And the moment that occurred, it was adopted. It went into effect on March 1st. We filed on March 6th. We got comments back, and we refiled on March 20th. So we were locked and loaded, ready to go from all the work that had precursed the efforts that were made with staff, admittedly with a different planning director, but notwithstanding that direction was put in place. So with that, Mr. Chairman, I thank you for your indulgence. Mr. Ferguson, I think, just has a few minor comments from a planning perspective with respect to the mistake argument that we would just like to have added for the record. but it is in written format, which we would incorporate and adopt as further testimony here tonight. So, Mr. Chairman, with your indulgence, I would just like Mr. Ferguson to say a few words.
Certainly.
Thank you.
Folks, Mark Ferguson with RDA Site Design in Upper Marlboro. And to Matt's point, a lot of the questions you had of Mr. Hager and Mr. Brinkley were things that I would have said in my testimony, so you get to hear less from me, which is probably a good thing. To Matt's point about the mistake argument, I think one thing that from my perspective is worth pointing out is a little bit less technical than than a legal perspective, but I play with lawyers a lot, is that a mistake in zoning sounds like something that is a wrong, something that's a bad thing, and it isn't. It is effectively a legal argument, and that is, were there facts that, had they been considered, you could have come to a different conclusion. And what Mr. Brinkley has told you is that they said, look, we're not even going to look at town centers until such time as we do the town center master plan. So definitionally, all of the facts about this property weren't considered. So that's a logical thing to do, and I wouldn't call it an error, but it fits technically what a zoning mistake is. So you're not casting shade on anybody by saying there was a mistake made. It's a technical term, a term of art. And really the question before you is what Matt has been arguing, before. You've got a choice to do something now, to have the dash-in folks really jump right on the redevelopment and have something happen. I mean, right now, in Owings, there's a number of empty properties. The bank is up for sale. There's, I think, 2 offices and maybe a body shop that are going. It's kind of quiet, right? And whether or not it's across the street, having somebody come in and spend a couple of $1 million putting in new landscaping, a new and nicer structure, septic that'll support, the offerings they have in the facility, a little bit more room to maneuver around the gas pumps so you don't have to back in and out if somebody else is already there. That might let other business owners say, yeah, it is worth putting some money into my property here in Owings. And in that sense, time does matter. I live in Hyattsville, Maryland, and I have for a long time. When I moved in, the stretch of Route 1 through Hyattsville was nothing but used car dealerships. I guess Lustine still had some new cars for sale there, but basically it was a wasteland. And 25 years ago, a buddy of mine, opened a restaurant. And it was the first new construction on Route 1 in 50 years. And right after that, a local DC developer and home builder called EYA went and looked and thought, oh man, he's making this work. And they went and bought up all of the old Lustine used car wasteland and turned it into a brand new, wonderful development because they saw it work. So there's a gentleman who was county council member back then. He was just recently chairman of the planning board in Prince George's County. And he had a wonderful article, where he was quoted in a wonderful article in the Post about the redevelopment of Hyattsville. And he said, developers are like penguins, and they all stand up, crowded together on the flow of the iceberg, looking into the water, and then one of them jump in, and then they all just sort of, after. And it really is, true. Somebody needs that, faith that, okay, somebody else is going to do it, so I won't be alone. And I guess that's what we're asking, to give you, Dash-in, a chance to be a penguin.
Yeah, Mr. Chairman, just in conclusion, I just want to highlight, thank you, Mark. We believe, and I think the record supports, and there's substantial evidence, and staff has alluded to it, but it does correct a zoning mistake, not necessarily an error. I don't want to, as Mark indicated, we're not here to say somebody did a bad thing, but There was a decision that was made not to look at this, and by not looking at it, it meets the definition of a zoning mistake, because if it had, I think a different outcome would have come of it, which is the outcome we're asking for this evening. So we do believe it corrects a zoning mistake in the last comprehensive rezoning. It aligns with the comprehensive plan's future land use map and town center vision. It supports the redevelopment at a core intersection of the Owings Town Center. It provides policy benefits by supporting compact town center focused redevelopment. It coordinates with and strengthens the upcoming Owings Town Center plan update by not creating any issues with it, as your staff articulated. Provides a community benefit through modern facilities, safety improvements, and compatibility with surrounding land uses to ensure economic viability. So with that, Mr. Chairman, Planning Commissioners, if there's any questions, we're happy to answer, but thank you for your indulgence and for allowing us to present this evening.
Gentlemen, thank you so much for your presentation.
Thank you.
Commissioners, questions? We're okay?
Thank you, sir.
Thank you so much,
you,
gentlemen. We
gentlemen.
appreciate your time.
Yes, sir.
Okay, that brings us to testimony. Do we have anyone signed up to speak?
This is public comment.
Do we have anyone else for testimony? And then that we'll move on to concluding comments of the applicant. I think we've,
Do you have any other witnesses?
No, we have no other witnesses, just
Okay.
I believe all the signees are.
For you guys,
representatives of us,
okay.
yeah.
All right, does staff have any other concluding comments? Okay,
No.
we go into public comment.
okay. All right, so that brings us to public comment.
Is there any public comment?
Okay, we don't have anybody from the audience signed up to speak. Is there anyone in the audience that wishes to speak? Are there any? Okay, no hands on Zoom, so that brings us to action.
Gentlemen, would anybody like to make a motion?
Yeah, I'm ready to make a motion.
Commissioner Berry?
I move that we close the record, find the proposed map amendment in MA 2501 is consistent with the county comprehensive plan, and that a mistake was made in current zoning, and recommend adoption by the Board of County Commissioners.
Thank you, sir. Do we have a second?
Second.
And we have a second. All those in favor?
Discussion.
Whoa, discussion, certainly, sir.
Yes. I cannot support moving 1, 2, or 3 properties specifically to a town center on the opposite side of a highway, especially when pending comprehensive plan updates within 12 to 18 months. My personal thoughts. Thank you.
Thank you, sir. Any other comments? Ready to take a vote? All those in, Becky, you need these by name, don't you? Yeah, I'm gonna do a roll call vote on this one because of, the technicalities. Commissioner Berry?
Aye.
Commissioner Freeland?
Aye.
Commissioner Gadway?
No.
Commissioner Kernan?
Aye.
Commissioner McQueen?
Aye.
Commissioner Weems?
Aye.
And I vote aye. It comes to 6-1 there. And you got all the names, ma'am? Okay. Thank you so much, and thank you, everybody, for all your input today. Well, you want to bring us to the next one?
Okay, that brings us to zoning text amendment TA 2502 through 2513.
You gotta take them one at a time, though.
And, yeah, we will take them one at a time. So the first one, we'll go
And by
through
one at a
them one
time,
by
we're going to go
one.
all the way through to action, correct?
Yes,
Correct.
and we
Thank
will
you.
let you know which ones we're on.
We're just getting started, guys. This is it's going to be a little bit of a journey here. So, like with the previous presentation, I'd just like to begin with a statement that this public hearing has been duly advertised and that we did receive no written comments in regard to any of these proposed text amendments that are subject to tonight's public hearing. Okay, so we'll begin with some background. A comprehensive rewrite and update of the zoning ordinance was adopted earlier this year and came into effect March 1st, 2025, as has been discussed. Text amendments are being proposed to address recent changes made to state law, updates required by Critical Area Commission following their comprehensive review of the zoning ordinance, to bring the zoning ordinance into alignment with updates currently in progress with the agricultural preservation rules and regulations, and to address a few outstanding issues not addressed with the recent zoning ordinance update. And I'd also like to note that an informational work session was held with the Planning Commission in June, where text amendments 2502 through 12 were introduced and discussed. An informational work session was also held in July, where text amendment 25-13 was discussed. So the first text amendment, 25-2, proposes to revise the definition of retaining wall to make clear that it does not include walls less than 36 inches in height. Anything less than 36 inches in height isn't considered structurally suitable for retainment. So this is really about making a clear distinction between walls that are constructed specifically for retainment, which must meet requirements like setbacks and are inspected, and smaller, more decorative walls used for things like landscaping. Moving on to text amendment 25-03.
Will, that's it. They get to.
Oh, they,
Yeah,
okay.
we're gonna do that one. So, Planning Commission, questions to staff? There is no applicant, so we're not gonna have a presentation, correct?
Correct.
That's correct. Okay, but there is no questions. Testimony?
I have one question. You
Oh,
are going
certainly,
to
sir.
require a engineered cert for the design and everything of the retaining wall to make sure that it will hold what it's designed to hold, if it exceeds the 36 inches or not? As the inspector goes out there and looks at it, I mean, he needs something other that's gonna let him know.
That would still
that
be
it's-
required. That would still be required.
That's still required, okay. Okay.
Okay.
I didn't hear part of that question. Was that for if it's over 36 inches?
Yes.
So this definition would make clear that it needs to be 36 inches in order for it to be considered a retaining wall, because anything less than that is just not going to be structurally viable.
Right. So if a quote-unquote wall is 35 inches, there's no need for engineering or design or permits, or because it's not a
It's
retaining
not a
wall,
retaining wall.
it's called landscaping. Thank you.
So do we have any concluding comments, Will?
I don't think I've got anything further to add on this one.
Well, thank you. We appreciate all your efforts so far. Public comment? We have anybody signed up for public comment?
No, we have one person, Paige, I think that's right. Is that for
That's the next one.
next one?
That's the next one.
Yeah.
Is there anybody interested in making a public comment at this time?
Is there anyone online that wishes to comment on this? No hands are raised.
No hands are raised. Okay. Would anybody like to propose an action on this one?
Mr. Chair, I'd like to move that we close the record, find the proposed text amendment in TA 25-02 is consistent with the Calvert County Comprehensive Plan, and recommended adoption by the Board of County Commissioners.
Thank you, Commissioner Gadway.
Second.
And we have a second from, who's that? Was that Commissioner Williams? Thank you, sir. All those in favor?
Aye.
Aye. It passes unanimously. Thank you so much. Thank you, Will. We can move forward.
So the next text amendment is 25-03. And this is going to be a few slides. The amendments for the next two slides are proposing to remove portions from the zoning ordinance, proposing to remove provisions from the zoning ordinance that we believe are more appropriate for inclusion in the agricultural preservation rules and regulations. The provisions on this slide specifically address the Agricultural Preservation Advisory Board. These are provisions that we only included in the zoning ordinance because for the time being, if they weren't written in the zoning ordinance, they wouldn't have been written down anywhere. But now that we're making progress towards adopting the updated agricultural preservation rules and regulations, we no longer believe they need to be included in the zoning ordinance going forward. And then the same comment on this slide as the previous slide. These are provisions addressing preservation areas and APDs that we believe are more appropriate for inclusion in the agricultural preservation rules and regulations. So just to be clear, we're not talking about making substantive changes with these amendments on these two slides. We are just moving these provisions over from the zoning ordinance to the agricultural preservation rules and regs.
Well, are they already there, or is there going to be or is that something that has to be done in the future? Is there going to be a gap?
They're in the draft. They're not in the current.
So there would be a
They've been
gap.
moved over to the draft.
What's that?
They've been moved over to
They've been moved over to the
draft rules and
draft.
regs, so when the updated rules and regs is adopted, they'll be in that document.
And is there a gap in between? If we take them out today, well, we're not going to do that, but if the county commissioners take them out next Tuesday, they do not apply for a certain period of time?
I believe that September 30th is the date where both the rules and regs and these tax amendments are planning to be heard by the BOCC.
Okay, so there would not be a gap.
Correct.
It's coordinated.
As currently planned, no.
As currently planned,
They're
so yeah.
both, this will, assuming a recommendation from this body, I think they're intended to go in front of the BOCC along at the same time as this proposed amendment. Is that correct, Jason?
Question for council.
Yes, sir.
Is it possible to make a text amendment recommendation contingent on something else, i.e. exactly what we were talking about, the total rewrite of the?
Yes, but I would recommend doing it in the affirmative and doing it, we recommend the text amendment with the following. Like, let's say you wanted to exclude certain acreage. I recommend the text amendment, but further recommend the exclusion of, I don't know, parcels greater than 50 acres. A contingent recommendation isn't really a recommendation, okay? Because what you're saying is I'm only recommending it if my way goes through. So what you're really doing is changing the proposed amendment to your own independent
Understood.
recommendation. Does that make sense?
Understood. I'm just trying to figure out if this were to pass and the other were to fail, it would leave a pretty big gap.
Well, potentially, but I am, once again, this is just saying, well, we find it consistent, and then what's going to be in front of the Board of surely the Board of County Commissioners wouldn't leave this huge gaping hole, but I understand what you're saying. What that would leave, please remember, there is currently rules and regs in place, so it's not like we're abandoning everything to the wind. There are ag pres rules and regulations that are currently pending. It's just that there's a new set of rules and regs that are being proposed, and we're stripping out, and probably staff should talk to this more, we're stripping out Article 4 of the zoning ordinances discussion of the ag pres rules and regs. So we're making it independent, and because the ag pres has its own board, everything goes in front of them. So, did I say that? I think I said
Well,
it correctly.
The part that Will kind of scares me is when you said if these regulations weren't written here, they wouldn't be anywhere else. And so if they're nowhere else right now, by removing these, or recommending that these be removed.
I think he meant the origination of it.
Okay,
Originally, that was correct, but we've
Okay.
come up with, since the 80s, we've had rules and regs. But obviously, the zoning ordinance predates the ag pres rules and regs.
okay.
I think I hope I'm not speaking for you.
Well, actually, for the slides that we just went over, we specifically included those in this zoning ordinance
Yeah.
update because they weren't in the current rules and regs.
Okay.
So that, what I said was sort of literal.
Oh, well, then I stand corrected.
So Will, do I understand you correctly that everything in here that's being deleted is being moved over to the Ag Pres rules and regulations?
For these two slides, that we haven't gone over the entirety of this text, but for these two slides, everything that you see in red is just being copied and pasted over into the draft rules and regs that are scheduled to be adopted on the time frame that they are.
So as we move through the presentation, there will be some that is planned to be deleted that did not move?
I would say that, well, I can go into the next slide and.
Well, Jen is.
Good evening, everyone. Jennifer David, I'm the rural planner. I have been working with the Agricultural Preservation Advisory Board on the rules and regulations. So let me give some clarification, which would have come later in my presentation. So first of all, in regards to this amendment, which is 25-03. So if we go down to item E, that item there, Agricultural Advisory Board, that actually is being moved. We are separating the rules and regulations into two documents. I'm here to present the rules and regulations later this evening for some of the changes that are going to be there. But what we are going to be having moving forward is a document for the bylaws for the Agricultural Preservation Advisory Board, and a document specific to the rules and regulations in which to apply the program, to apply the rules of the program, and to administer the program effectively and and for consistency with the comprehensive plan and the zoning ordinance. So that item there, item E, where it references the Agricultural Preservation Advisory Board, that's E1 through E8, that is moving to the bylaws. So it's moving out of the zoning ordinance and into the bylaws for the Agricultural Preservation District. Under district standards, that language that is being removed now is not in the draft rules and regulations. And the reason it is not in the draft rules and regulations, as I will get to in my presentation, the rules and regulations are being proposed to repeal and replace all previous versions of the rules and regulations. Thereby, agricultural preservation district owners, should it pass in that way, would be applicable to the same set of rules and regulations instead of the set of rules and regulations that were in place at the time that the APD was created. So that one first sentence there, that is not in the rules and regulations. Does that answer the question? In the draft, excuse me.
I think so. So Will, forgive me if I'm kind of jumping the gun, but I'm looking at the exhibits that you presented, and on slide, it looks like 2 of the 9, 4.4-2 Agriculture Preservation District, APD in parentheses D. You with me?
What was that page again?
I have slide 2. Let's see if I can find a page number. No, I don't. I can't see a page number. It's in your exhibits.
District standards or preservation areas.
So if it's under district standards, then it's the slide that we're looking at currently.
All right.
PowerPoint, correct?
So show me where the section D, strike through, shows up in the new rules and regulations. Specifically, the language that says agricultural preservation district shall be governed by the laws and regulations in effect at the time it created.
So what Jen said was important there, because she corrected something. What I said earlier was an error. I'd forgotten that provision was on this slide. So she was correct in saying that that specific provision is not going to be carried over into the agricultural preservation rules and regs, the draft that's up for discussion.
And was that a recommendation from the APD board?
So the APB board, a recommendation to remove that language from the zoning ordinance was not discussed with the APB, but inherently it is, the Ag Board had been working on a sole set of rules and regulations in which to apply to all APDs. So by inference, it makes sense. Does that
Thank you,
help?
Jen.
Are there any other questions on these two slides before we move further on?
Specifically, was that put in front of the attorney for legal efficiency?
That part was not.
It was
I
not.
have not reviewed for legal sufficiency on that. It does raise an issue. I mean, I'll tell you what the issue is if the board
Please,
wants to
please
indulge
do.
me.
Yeah.
Well, if I put my property into Ag Pres, and at the time, I'm guaranteed, it's almost like a contract, I'm saying, you have these rights and entitlements when you put your property in. And then, so I put my property into Ag Pres under a guarantee or a certainty that that is the rule that's always gonna govern my property. And then later, those rules are changed. That might be construed as a taking. So, I mean, I am pretty sure that the people we see here are probably gonna raise that very issue.
So I don't have a legal perspective on this. I just work on the zoning documents. So I can just, from my perspective, even if there's issues with that specific statement coming out, we would still eventually want to take it out of the zoning ordinance because we would still feel like that was a more appropriate, the rules and regs would be the more appropriate location.
And I'm not saying that, but I'm not saying that that isn't. I think I even said that earlier because I thought that the new rules and regs were going to encompass that. But I'm sure the people here, and I'm not going to speak for them, are going to say, well, before you do that, we'd like guarantees that the assurances that were made when we put our property in Ag Pres are going to carry over. But I'm not going to advocate for them. I'm sure they'll do it themselves.
I just seen that this looks like the cart in front of the horse. If we've got rules and regs coming, and we've got a draft in place that would materially affect this particular text in the zoning, why wouldn't we wait until that was discussed and approved prior to looking at removing this first? If the new was going to encompass everything here, put the new in effect, then let's come back and eliminate the redundant text in zoning.
Well, I would point out one thing. By doing that, if you don't take Ag Pres out of this, then actually the Ag Pres rules and regulations are never going to get in front of the Board of County Commissioners because there has to be, either you take it out of the zoning ordinance and have a public hearing for taking it out of the zoning ordinance, or you have a public hearing on the rules and regs, and then it goes in front of the BOCC. The BOCC can never rule, never make a final finding unless it comes through the Planning Commission in public hearing first.
Don't we have that later on the agenda tonight for the rules and
We only
regs, the
have for
repealment?
information purposes only tonight
Okay,
at the regular meeting.
right. But that means that's probably going to come to fruition at some point, I would imagine, or it's not gonna be coming
Well,
up for.
if it's stripped out, if in fact the ag pres rules and regs are stripped out of section 4, article 4 of the new zoning ordinance, then there's no need for the rules and regs to come for a public hearing in front of the planning commission again, because it's been stripped out. So it's independent, and then it would go directly to the BOCC for their approval. So in other words, we either rule on stripping it out, following a public hearing on this amendment, or we're gonna have to have a public hearing on the rules and regs. One way or the other, it's gotta go through us in public hearing before the BOCC can rule on it.
So, I mean, right now, I think I would support moving it along to make everything fall in place, but I believe I would offer a condition.
Well, I mean, that's certainly within your purview. Like I said, I generally think it's cleaner and less, and easier to survive a challenge if we do the recommendation in the affirmative, or say, no, we approve it with this language, and then make that recommendation forward, obviously after a finding that's consistent with the comprehensive plan. But we still have public comment, we still
Yeah,
have,
I'm looking forward to that.
so,
Council.
I have a question.
Yes,
What
sir.
has more teeth, the ordinance or the rules and regulations?
well, always, at this point, obviously the zoning ordinance. Interestingly enough, if in fact it's stripped out of the zoning ordinance and the rules and regs go through the BOCC, it actually has equal standing, because then it actually has the power of law. It basically becomes like an ordinance in and of itself. So at this point, zoning ordinance out obviously has the greater authority, because we're just talking about rules and regs. But once it's stripped out of the zoning ordinance, if the BOCC does adopt it as its own separate viable document, it would be an ordinance in and of itself. So as of now, the zoning ordinance has greater teeth. Does that answer your question, Mr. Williams? Okay.
Which leads me to another question.
Yes, sir.
If I understood you, and please correct me if I'm wrong, that the repealment and replacement of the APD rules and regs, if I'm using the correct terms.
Okay.
Or close to it,
It's close to, yeah, sure.
that's on the agenda for later this evening on the regular session. Are you saying that if,
Well, can I just stop you there?
Okay.
For tonight, it's just for information purposes only.
understood, but I
Okay.
mean, okay. It's for informational purposes this evening.
Yes, sir.
Did I understand you correctly that if we leave this in place, and I hate trying to discuss, and I'm glad we don't have a motion on the floor because it'd be in violation, but did I understand you correctly that the rules and regs, the repealment and replacement, if we were to approve these text amendments tonight, the rules and regs repealment and replacement would not go to public comment?
Correct. The reason why it would have to go in front of you, but for stripping it out, is because anytime there's an amendment or change or adoption of anything regarding the comprehensive plan, or in this case, the zoning ordinance, which is a baby of the comprehensive plan, if you will, has to first go in front of this body for, number one, the most important thing is a consistency finding, because no other body in Calvert County government can give a consistency finding. So that's number one. And number two, anytime there's a change, you have to have a recommendation from this body to the BOCC. Now, the BOCC doesn't necessarily have to accept our recommendation, but they have to have it before they can rule on it.
But if I understand what you're saying, the BOCC can arbitrarily repeal and replace the APD rules and regs without this body's suggestion or public comment.
As long as it's consistent with what's currently in Article 4, that is correct.
So if we left this in place, they could not do it because the first sentence is not consistent.
Correct. Well, they can change it as long as it doesn't conflict with the currently enacted zoning ordinance, because even they can only change the zoning ordinance after it's come through this body for recommendation and a consistency finding.
Okay.
help me to try and figure out a way out of this conundrum if we could hear the public comment?
I'm looking forward to it as well, my friend. Are those the concluding comments?
So
Can
we
move forward?
haven't gotten
Okay,
through
so
the
we-
entirety of this text.
Okay,
Ah,
so we
keep
have-
going, buddy, keep going.
Sorry about that.
I tried.
I'm trying to.
I saw the kids leave. I thought it was time for me to go too.
Okay, just a few more slides. So on this next slide, the revisions we're looking at here proposed for landfill land clearing debris are in the same spirit of what we've been talking about, making sure the zoning ordinance is not in conflict with the agricultural preservation rules and regulations. So under the proposed revisions, the conditions for APDs would be as follows. Number 3, on land that is designated as an APD, only debris originating on the APD are permitted, and on land that is designated as an APD, the landfill can cover no more than 5% of the APD and shall not be visible from a public right-of-way. Any questions on that one? Hearing none. And the amendment on this slide just makes it clear that landfill land clearing debris is a conditionally permitted use for APDs. The amendment to sand, gravel, or mineral extraction makes clear that in APD's approval of the Agricultural Preservation Advisory Board is required. And the amendment here is changing this use from requiring a special exception from the Board of Appeals to just being a conditional use in APDs, with one of the conditions being approval of the Agricultural Preservation Advisory Board. We felt that requiring property owners to also get approval from the Board of Appeals was redundant and unnecessary. So that is the concluding slide for text amendment 2503.
Thank you, sir. So as the concluding slide, it leads us to concluding questions by Planning Commission? That'd be next. Public comment would be next. There's no testimony or there's no applicant, correct?
Correct.
Correct.
So we are at concluding comments of staff.
Correct.
Does anyone on staff have a comment? So that brings us to public comment.
All right, we are at public comment. If there is anyone online who wishes to speak, you can raise your hand by doing *9. We're going to start with the in-person first. On the speaker sheet, we have, is it Paige Raw? Raro. Okay. And are you,
I'm counsel, and I'm here for a group of people who have property in the districts, and a number of them are in the audience, and a great number of them could not make it tonight, but are very much interested in the outcome.
okay, you will have 5 minutes.
Good evening, Paige Wyro. You guys raised a lot of the issues already, so I'm going to bounce around a little bit for some of the questions that some of you raised. Mr. Freeland, you raised the question of whether or not the proposed rules are properly going to go before the county commissioners. I would tell you that they are not. How can the board of the APB board consider whether or not they ought to vote for rules without knowing whether or not the rules are to be made retroactive or not? And that is and your body's, the Ag Pres board is supposed to make a recommendation, and you made a recommendation in a vacuum. So what's before you tonight is a rule, or a change to the zoning rule, which would strip the language out of the zoning code which says that the rules governing any district are the rules in place, in force at the time the property is placed into the district. Now, if you go to the county's website, in which the changes to the district are discussed, The first goal identified, and it's attached to the testimony tonight, indicates that they want one set of rules applicable to every single district that's ever been created in the county. So what does that mean? That means that rules, if they change the rules today, they want to apply those changed rules to districts created 30 years ago. And in fact, in one particular instance, they are doing that. 30 years ago, tenant houses did not count towards your density. What was the benefit of that to the farmers? The tenant houses went with the main house. They continued to get the rental income and use of those tenant houses for people that helped them on the farm. Plus, they got to create 3 lots and sell those lots to generate income for themselves and the farm, or to give lots to their children. Now, under this current zone, they want to impose on these districts the requirement, you got to pick one. You only get one. You no longer get 3 lots and 3 tenant houses on a 100-acre district. You got to pick. You either keep the income from your rental properties, or you develop the 3 lots and give up the tenant houses, because you can't have both under the new set of rules. And that's not fair to people who put their property in the district, as Mr. Mattingly said, and made an agreement 30 years ago. I'm going to forego, in some instances, the ability to cut 15, 18 lots out of my farm. I'll agree to 3, but if I got tenant houses, they don't count toward my density, and I continue to get the rental income from them. These rules take that right away. And to the constitutional issue, a taking, it goes further than that. There's due process violations, and I will tell you that there was a long line of Supreme Court cases, as you can imagine, on issues like this. The most that a Supreme Court has ever allowed an ordinance to be placed, to be made retroactive in instances like this, is 70 years. 7 years. 30 years isn't close. The 30-year retroactivity in a case like this has been rejected out of hand by the Supreme Court on more than one occasion. You are opening yourself up to due process claims. You are opening yourself up to taking claims. Moreover, the express purpose of this is to create new ag-pres districts. Well, what it will allow the county to do is, if today somebody new or somebody old has a district that's 100 acres or more, and assume no tenant houses for the purpose of this example, that person is allowed to carve out 3 lots. The county could decide a year from now, 5 years from now, you know what, we don't like this density stuff anymore. We want to shut it down even further. We want to lock the door, throw away the key.
You have 30 seconds.
And so they could decide, and they got to go through the process, admittedly, that property that's been in the district for 40 years, they're going to take away the right to put 3 houses on it, because there's nothing in the rules which say what rules govern. I would urge you to reject it. I don't know why it's being considered piecemeal. It makes no sense. How can you decide whether or not something ought to be retroactive if you don't understand what the new proposed rules say? And I would leave it in place until the Ag-Pres Board passes on the retroactivity aspect of it, and there is a guarantee that the rules that will govern any district are the rules that were in the place at the time it was created, and that language is included in the proposed rules that you consider and that the county commissioners consider. Thank you very much for your time.
Thank you, sir.
That brings us to action.
We have no other public comments?
I'd like to make a motion.
I'm sorry, sir?
I'd like to make a motion.
Why, certainly. I'd love to hear it.
Okay, beat me to it. Thank you. I move that we close the record and find that the proposed text amendment in TA number 25-03 is not consistent with the Calvert County Comprehensive Plan.
Second.
We have a motion and a second. I'll go to do it by, Commissioner Burr, you seconded?
No.
Gadway.
No, Mr. Gadway, sorry. Commissioner Gadway. I got the corner right. Commissioner Burry?
I concur with the motion.
So that's a yes?
Yeah.
Commissioner Freeland?
Yes.
Gadway?
Yes.
Kernan?
Yes.
McQueen?
Yes.
Weems?
Yes.
And I'll vote yes. So there we go. Unanimous. Okay, thank you.
All right, moving on to the next text amendment. 25-04. So this next text amendment proposes to relax some of the regulations regarding uses in APDs. The amendment proposed on this slide would allow bed and breakfast facilities on APDs as long as the dwelling in which the facility operates was constructed prior to March 1st, 2025. And in addition to allowing bed and breakfast facilities as a conditional use in APDs, this amendment would also allow food trucks as a conditional use in APDs beyond those already allowed as accessory uses at events. So that's 2504.
Okay. Do we have any questions by the commissioners to the staff?
Yeah, what is the county's concern with creation of additional bed and breakfasts in this area for new buildings after March 2025?
I think that there's sort of a debate about commercial activity in APDs, and I think that existing dwellings, we consider that less of an issue, whereas someone were to build a new dwelling specifically for a new commercial enterprise like a bed and breakfast. I think that was the thinking behind having that condition.
Any other
I'm
questions?
trying to
Sorry.
balance the property owner's interest in using his property to generate more revenue from a bed and breakfast with a general community attitude about what the permitted uses ought to be. And I'm not familiar enough with the community attitudes to render a judgment.
I have a comment also. Not all bed and breakfasts necessarily are serving breakfast to everybody. Some of the rooms could have a kitchenette. So if you really look at, I mean, I'm trying to understand why you got certain things, and you say meals be served to overnight lodgers only. But if it's your house, you're serving a meal to your family. Your family could come over and you serve a meal. This is really specific. I don't understand it. I think it's not right.
Any other questions or comments? So that takes us down to the testimony and the concluding comments of applicant and staff, which we don't have, correct?
Correct.
So that brings us to concluding questions by planning commissioners. Are there any? Setcha? Okay. Public comment?
We don't have anyone here that wishes to speak or anyone online.
Okay. And is there anyone here who actually does that didn't get a chance to sign up? Okay. In that case, it brings us to action. Would anybody like to make a motion? It's a non-motion of people down there. That's what's down this end. No, that's a non-motion of people. Any motions?
No motion dies on the vine.
Eyes on the vine without a motion.
Well, that's that. Last call for motions?
It
She
does,
dies.
I will say the one thing, by not making a motion, it does allow staff to rebring it, or any
Sure.
member of the public to rebring it. So
Understood.
there's no presidential
Yeah.
effect.
I'd love to hear more arguments pro and con in a future session.
No motion.
Okay, no motion. Well, where's that bring us to?
Moving along, we're at 2505. So this text amendment makes clear that if a use is not listed or does not fall within one of the general categories as determined by the zoning officer, it is not permitted either by right or special exception in any district. And this is the only slide for this text amendment.
And that's just replacing the word permitted use is not a permitted use with is not permitted either by right or special exemption.
Clarification.
Understood.
Okay. Do we have any questions on this issue? No? Set? We have no applicant. We have concluding comments of staff, Will? No? Concluding questions by planning commission members? No? Public comment?
I have no one signed up to speak. Someone just joined. Is there anyone who is online that wishes to speak? Please do *6 to unmute yourself if you wish to speak.
Nope.
No one.
All right, it brings us to action. Would
Mr. Chair,
anybody-
Mr. Chair,
Yes, sir?
I move that we close the record, find the proposed text amendment in TA 25-05 consistent with the Calvert County Comprehensive Plan, and recommend adoption by the Board of Calvert County Commissioners.
Thank you, sir. And we have a second?
Second?
And we have a second, I'm sorry, who was that?
Me.
That was Mr. Burry. Okay. And again, we'll do it by, well, I don't know, no. All those in favor?
Aye.
Aye. 7-0. Thank you. Okay. Will, it's yours. 06.
All right, 2506. This is a text amendment proposes to allow garden centers or farm supply stores in the farm and forest and rural community districts with the condition that the combined gross floor area of all buildings supporting the use be limited to 7,500 square feet. And the 7,500 square foot threshold was chosen because greater than 7,500 square feet would trigger the requirement of a Category 1 site plan. And next slide is just showing where on the use chart the districts where this would be conditionally permitted. And that's the conclusion for 2506.
So it limits them to 7,500 square feet. Do they have a size limit now?
They're not permitted at all in those two districts, the farm and forest or rural community district currently.
So this expands there
They would be limited in size, but they're not permitted at all
currently.
in those two districts.
Okay. Questions, comments, gentlemen? No? So we have no applicant again, correct? Any testimony? Concluding comments, concluding comments? Concluding questions? Public comment?
I do not have anyone that signed up to speak. Is there anyone online that wishes to comment on this text amendment? Please do *6 to unmute yourself. *6. No one.
No comments. Would anybody like to make a motion?
Motion.
Sir?
Move that we close the record, find the proposed text amendment in TA 25-06 is consistent with the Calvert County Comprehensive Plan and recommend adoption by the Board of County Commissioners.
Second.
And we have a second, I believe, Commissioner Weems?
No,
The motion was from Commissioner Kernan. Okay. And do we have any comments, discussion? All those in favor?
Aye.
Aye. So that's 7. All right, number 7, Will.
All right, that brings us to 2507. And so this amendment adds a condition that specifies that an accessory dwelling not be greater than 75% of the gross floor area of a single-family detached dwelling, bringing it into alignment with how the state defines accessory dwelling units. And with the legislation on ADUs that was passed in Annapolis recently, the state is limiting how local jurisdictions can regulate accessory dwelling units. And one of the limitations is that a local jurisdiction cannot establish setback requirements that exceed the existing accessory structure setback requirements from side and rear lot lines. So that's why we're proposing to remove the existing language from condition number 6. And I should note that a requirement currently on the books is that all accessory structures 500 square feet or greater must meet the setback requirements of a primary structure. So this amendment would essentially only be a substantive change for accessory dwellings less than 500 square feet in size. And we're proposing to add a condition that the accessory dwelling have adequate vehicular access as determined by the Department of Public Works. We believe this type of requirement is within the purview of the type of regulations on accessory dwellings allowed by the state, and we believe it's common sense.
And Will, these were allowed, would be allowed on private well and sewer?
Accessory dwelling units, they're currently allowed on, yes.
So you had a 4,000 square foot house. You could have a 3,000 square foot?
These aren't all the conditions. There's still a 1,500 square foot limitation. So a detached accessory structure cannot be more than 1,500 square feet. And if it is attached, I believe there's another condition that limits the size, the maximum size of the accessory dwelling. So there are layers to the size constraints.
And it doesn't need to be said that the property needs to meet the private water and sewer capacity for the.
If the health department says no, then they say no.
So that's part of this site plan review process, correct?
Correct. The health
Okay.
department does review it.
Okay, any other questions? Any concluding comments? Any concluding questions? Public comment.
I do not have anyone in person that signed up to speak. Is there anyone online who wishes to comment on this text amendment? Please star 6 to unmute. No one.
No one? In that case, would anyone like to propose a action?
I propose that we close the record, find that proposed text amendment 25-07 is consistent with the Calvert County Comprehensive Plan and recommendation of adoption by the Board of County Commissioners.
Thank you, sir.
Second.
We have seconds from all over. Did you, Commissioner Weems did? Okay. All right, any comments? All those in favor? Aye?
Aye.
Aye.
Aye. And there are none against? We have 7. Thank you, ma'am. Okay, we're up to number 8, Will?
All right, I believe we're about halfway through. All right, text amendment 2508. So the revisions being proposed in this text amendment address some outstanding issues related to daycares and home daycares as home occupations. What we're looking at on this slide and in the next slide addresses parking requirements for home daycares. These revisions would require home daycares to provide 1 drop-off parking space in addition to parking spaces required for the dwelling as well as an additional parking space for each employee that is not a permanent resident of the dwelling in which the home occupation is located. The revision on this slide reduces the parking requirements for home daycares and daycare centers with 12 or fewer clients from a pickup drop-off area that accommodates 2 cars and reduces it to 1 car. And the revisions on this slide and the previous slide would bring the parking requirements for home daycares into closer alignment with the requirements under the previous ordinance. This text amendment also proposes to relax some of the requirements for home occupations generally. Special exception approval from the Board of Appeals would no longer be required for Class A home occupations. A Class A home occupation are those where employees must be a permanent resident of the dwelling, but on-site appointments of customers or clients are permitted. With the exception of home daycare centers, only 2 clients or fewer are permitted on premise at a time. And special exception approval for Class B home occupations would only be required in the Waterfront Community District and Residential District going forward. Class B home occupations are permitted to employ up to 2 equivalent full-time employees in addition to employees that are permanent residents of the dwelling in which the home occupation is located. The proposed amendment also adds a special exception requirement for daycare centers that serve 13 to 19 clients in the FFD, RCD, RND, WCD, and RRD. And a special exception approval would be required for daycare centers with 12 or fewer clients in the WCD, RD, in order to make it consistent with the changes proposed for home occupations and home daycares. So those are the slides we have for 2508.
Thank you, sir. Questions or comments?
One question, the definition of client, does that refer to the children under care at any
Correct.
given time? Okay, so it's not the parent who may have 10 kids.
I don't know why they choose that language, but
All right.
that is the official language. Yeah.
Thanks.
Okay. Any other questions, comments? All right, where does that bring us to on the list? We don't have an applicant, correct?
Correct.
Then therefore we have no testimony. Your comments are done, correct? Okay, any concluding questions by Planning Commission? Any public comment?
No one signed up for this text amendment. Is there anyone online who wishes to speak on this text amendment? Please do *6 to unmute yourself. No one.
Okay, would anybody like to make a motion?
I will. I move that we close the record, find the proposed text amendment in TA 25-08 is consistent with the county comprehensive plan and recommend adoption by the Board of County Commissioners.
Thank you, sir.
Second.
Can we have a second from the Vice Chair? Any comments, discussion?
Extension. I need an extension.
All those in favor?
Aye.
Aye. Are there any against? There's 7. Okay, and that brings us to number 9. Will?
Okay, 25-09. During the zoning ordinance update, one last-minute change we made was removing the use of public utility lines and accessory structures from the ordinance. We since decided that this use should remain in the ordinance, and that this was, and that's what this proposed amendment in the next 2 slides are addressing. So as you can see here, public utility lines and accessory structures would be a permitted use in all zoning districts in the county. And that's it for 2509.
Okay. Do we have any questions? All right, without a question, we have no applicant, correct?
Correct.
So therefore, no testimony. Brings us all the way down to concluding comments of staff. You're covered. Concluding questions by planning commissioners. You're all happy. Public comment.
We have no one signed up in person to speak. If there's anyone online who wishes to speak, please do *6 to unmute yourself. No one has unmuted.
Would anyone like to make a motion?
Mr. Chair, I'd like to move that we close the record, find the proposed text amendment in TA 25-09 is consistent with Calvert County Comprehensive Plan and recommend adoption by the Board of County Commissioners.
Thank you, sir. We have a second.
Second.
And we have a second from Commissioner Kernan. All those in favor?
Aye.
Aye. Any against? 7. Okay, wonderful. Brings us to 10.
All right. 2510. The revisions shown here are relatively minor and mostly just clarifying existing policies for accessory structures. A building permit shall be required for the construction or installation of an accessory structure 200 square feet or greater in size and is required for all structures within the critical area. And all detached accessory structures, regardless of size, shall meet the required setbacks in Table 19-1, unless otherwise specifically permitted or restricted by this article. And next slide. A few additional revisions in this section have been proposed. Item 7 allows for an accessory structure or use to be located on a property adjoining the primary structure or use if the following conditions are met. And the text in condition C has been replaced with the following: power generating systems and solar energy generating systems require a use and maintenance easement be platted. And item 8 is proposed to be added, which states that on a property without a primary structure, an accessory structure may be permitted if special exception approval is granted from the Board of Appeals. If item 7 above applies, a special exception is only required if conditions A or B cannot be met. And that's 2510.
That's 2510. Questions?
Will, for clarification, accessory structures would include examples, deck, sheds, gazebos, greenhouses. I mean, are those all inclusive of
Those
accessory?
would all be considered accessory structures. correct?
Okay, so 190 square feet, don't have to worry about permitting as long as they're not in the critical area.
If it's under 200, correct.
Right, okay, thank you.
Okay.
Just got to worry about setbacks.
Right.
Any other questions, comments? Go back to my list. Can I take it all the way down to, Will, do you have any more concluding comments? Any other questions from the Planning Commission? Any public comment?
There's no one signed up to speak in person. If there's anyone online who wishes to speak, please do *6 to unmute yourself. No one.
All righty then. Would someone like to propose an action?
Mr. Chairman, I would like to move that we close the record, find the proposed text amendment of TA 2510 is consistent with the Calvert County Comprehensive Plan and recommend adoption by the Board of County Commissioners.
Thank you, Commissioner. And we have a second from Commissioner Kernan. Are there any comments or questions? All those in favor?
Aye.
Aye. 7. There were none against, correct? Okay. Will, number 11.
All right, just one slide for 2511. The revisions proposed in this text amendment are also just mostly clarifying existing policies, specifically that final detailed site development plan approval shall be obtained prior to the issuance of any building permits for all Category 1 and Category 2 development. No permits are allowed to be issued until site plan approval is finalized, and final subdivision plat approval shall be obtained prior to the issuance of any building permits. No permits are allowed to be issued until subdivision approval is finalized, and that's 2511.
Thank you, sir. Questions or comments?
This applies to grading permits as well?
This is just site plans and subdivisions that we're discussing here.
Okay, so when there's language that says no permits are allowed to be issued until site plan approval is finalized, does that refer to
Oh,
grading
I'm sorry,
permits or
I
not?
think I misunderstood. Yes,
Okay.
I believe that would include grading permits. You're
Yes.
correct.
Okay, thanks.
Okay. Any other questions or comments? Any concluding comments from staff? Questions by planning commissioners? Public comment?
No one in person to speak. If you are online and wish to speak on this text amendment, please do *6 to unmute. No one.
And there's no one here?
No one in person, no.
All right. A motion?
Motion.
Sir?
I move that we close the record, find the proposed text amendment in TA number 25-11 is consistent with the Calvert County Comprehensive Plan and recommend adoption by the Board of County Commissioners.
Second.
We have a motion and a second from the Vice Chair. Any comments, questions, discussion? All those in favor?
Aye.
Aye. Are there any against? We have 7. All right, that brings us to 12.
Mr. Commissioner,
Yes, sir.
May I be recognized? I have a conflict on this and ask to be recused as your counsel.
Thank you, sir.
What will we do?
Okay. Just one slide for this one as well. So, under general provisions, condition 7 would state, temporary signs shall not be posted on any non-designated public property, including but not limited to rights-of-way, utility pole, signposts, or landscaping. For the purposes of this section, non-designated shall mean that public property for which the poster has not received express written permission to post the temporary sign from the appropriate governing authority for the public property. And that's 2512.
Thank you, sir. Questions, comments? I'm going to work my way down
Does
the
that-
list until I
does that
figure out who
include
you are.
Public right-of-ways?
Yes, sir.
Any other questions? There is no applicant, correct?
Correct.
So testimony? No. Concluding comments of no. Concluding comments of staff? Concluding questions by Planning Commission members?
Yes.
Sir?
As I'm reading through that again, just where does real estate signs, political signs, things like that fall into this equation?
Under recent Supreme Court, actually not that recent, 6-year-old, 7-year-old Supreme Court cases, signs now must be content neutral. So we have to pretend as though we don't even know what's written on them.
Okay.
So anything that splits out what the sign actually says would be a violation of the First Amendment. What we're basically trying to do here is stop private parties from using the land that belongs to everyone for their own purpose.
Understood, thank you.
So political signs can still go on my land, but not on the right-of-way adjoining it?
Yeah, this is just solely to keep private parties from using county and state right-of-ways as their own advertising vehicles.
Sure.
Besides all the safety issues, there's just the inherent unfairness
Mhm.
that public lands are being used by private parties, profit or for anything else, for that matter. So we're trying to keep our public right-of-ways, our state and county land, free and clear of signs.
Okay.
Question.
Yes, sir.
Sir?
How is enforcement going to be handled?
That's why this is great. There's a gentleman right here who's the bane of his existence.
Just one?
Well, the problem is there's currently no teeth under state law. So what we're trying to do is give the zoning ordinance authority over this. And by doing this, we make it enforceable. As it was written before, the only time the zoning ordinance would be implicated is if there was a finding by a judge that was destructive to the public property. This, however, will bring a zoning enforcement action against someone who places a sign in public land. Previously, it was a $25 fine for placing an illegal sign. The judges, and I'll just tell you flat out because I've probably prosecuted over 300, 400 of these, just won't take it seriously. They don't even want the cases brought before them for $25.
Sure.
Zoning ordinance currently places a fine of up to $500. So what we're hoping is by bringing this under the zoning ordinance, that people will start respecting the public rights of way.
Thank you.
I have a question.
Yes, sir.
Sir?
For somebody that puts up signs, such as I do, for people, I have a hard time understanding where the state decides where the signs should go and not go. And even when I talk to the state person, because I ask for specific information, because I want them in the proper area so that they don't, if they get defaced, I can follow up with somebody else.
So state law is currently written that there is presumptively 20 feet from the center line of the road to either side, okay? If it's two lane. Now, what I generally tell people is it's safer just to assume that if there's we won't enforce if it's inside the ditch. If there's a ditch, and even if it's state-owned or county-owned on the other side of the ditch, we're not gonna enforce because they're not surveyors, they don't know. Inside the ditch, we all know that's county right-of-way or state right-of-way, depending on who owns it. It is public property. The biggest problem we have, and I think there's gentlemen here that would testify to this, are when they put it in the actual medians and we clutter every intersection. And we as the county are spending, because we have to get them on Saturdays, so we're spending the overtime. The county is incurring the overtime to put these signs up that blow over everywhere, and anyway,
Puncture tires.
among other things.
Yeah.
But
How does this apply to, okay, it says temporary signs shall not be posted. How does that affect a person holding a sign? Or a person standing there with a sign post that's 3 foot wide, 8 foot tall, that's totally obscuring the person holding
Well,
it?
that wouldn't be.
And they're there for
that's-
8 to
well,
10 hours.
Well,
That's free
the
speech.
zoning ordinance doesn't have any authority over someone who can.
Yeah.
it's
Exactly,
only-
that's where I was going, thank you.
Yeah.
That's not a temporary sign under the
No.
definition of
Right.
temporary
Absolutely
sign.
not.
Yeah.
Okay.
All righty. Do we have then any concluding comments or questions? We have public comment.
I don't have anyone to speak, signed up in person to speak. If
I
there's
got
anyone.
smiles, I got nods, I got, I
If
got
there's-
all sorts of stuff.
Yeah, no, yeah.
If there's anyone online who wishes to speak on this text amendment, please do star 6 to unmute yourself. I have no one at this time.
Thank you, ma'am. Do we have a proposed action?
Mr. Chair,
Yes, sir.
I move that we close the record, find the proposed text amendment in TA 25-12 is consistent with the Calvert County Comprehensive Plan and recommend adoption by the Board of Calvert County Commissioners.
Thank you, sir. Do we have a second?
Second.
And we have a second from Commissioner Weems. Do we have any comments? All those in favor?
Aye.
Aye. Are there any against? 7. All right, Will,
Thank you, gentlemen.
Okay.
Permission to return to my station.
No,
permission
thank you.
granted.
Thank you, Jim.
Wonderful job.
All right. Finally, we're at 2513. Fortunately, I think we've got about 10 slides to get through. This is a big
Oh, you
one.
saved
I'm
the
gonna-
best
for
for
everyone's
last.
sake, I'm going to try to get through this as quickly as possible.
Take your time.
But just a reminder, the Critical Area Commission conducted a comprehensive review of Calvert County's critical area program earlier this year and recommended changes to the critical area regulations within the county zoning ordinance as a condition of the commission's approval of our local program. So those changes recommended by the Critical Area Commission as a condition of the commission's approval of our local program are why we're proposing text amendment 25-13. So the revisions on, shown on the slide are adding a couple additional statements to the purpose and goals section of the critical area article. Unless anyone wants to stay on this slide, I can move forward. Okay.
No, go ahead, I'm sorry.
Next slide. The revisions presented on this slide change the requirement that the critical area provisions in the zoning ordinance and critical area maps be comprehensively reviewed from every 6 years to every 10 years, and clarifying if the county requires a 1-year extension to the 10-year deadline, then they must notify the critical area commission in writing. And the revisions shown on this slide state that the county may grant a change to the critical area land classification on proof of mistake if the critical area classification conforms with the state area mapping criteria based on land uses in existence either as of December 1st, 1985 as part of the originally mapped critical area, or as of the date the land was included in the critical area due to critical area boundary remapping effort, and follows the county mapping methodology for critical area classification at the time of mapping, and is consistent with the purpose, policies, and goals of the critical area law and regulations. The revisions shown on this slide are some of the more substantive revisions included in this text amendment. This provision is in regard to lot coverage limitations in the limited development area. The new text in this provision states that for development that uses pervious materials that have been approved by the commission as part of a local program, the limits established in this subsection may be exceeded by up to 500 square feet using permeable pavers or permeable pavement installed in the manufacturer's specifications. The degree of perviousness shall be agreed upon by the Department of Planning and Zoning and shall fall within the ranges as defined in section 2-2 of this ordinance. Those terms are defined on this slide. Unless someone wants me to go over these definitions, I can move forward. And on the revisions on this slide are applicable to the growth allocation section of the critical area article. They state that when locating new intensely development areas or limited development areas, to locate those new IDA or LDA areas outside of areas vulnerable to climate change as identified by the county, and in reviewing map amendments or refinements involving the use of growth allocation, the county shall consider the following factors: environmental impacts on underserved or overburdened communities. We have definitions on this slide. Unless commissioners want me to go over there, I can skip to the next one.
Please do.
And the vision on this slide is in regard to habitat protection areas. And it states simply that maps identifying that these specific habitat protection areas are maintained by the Department of Natural Resources, Wildlife and Heritage Division. The most recent updated inventory was completed on March 10th, 2021, and recommendations contained within WHS's report, Habitat Protection Areas for Calvert County Critical Area, and associated maps are hereby incorporated into this ordinance. And on this slide, we have revisions to the definition of density and dwelling unit. The Critical Area Commission wants us to make the following revisions to the definition of dwelling unit, so that it would now state one or more rooms forming a single habitable unit with facilities for living, sleeping, cooking, sanitation, and other activities associated with daily life. Examples of dwelling units include, but are not limited to, accessory dwelling units, such as living quarters for a domestic or other employee or tenant, an in-law or accessory apartment, a guest house, or a caretaker residence. And we had some concerns with how that revision would impact our definition of density, so we are proposing to add the following statement to clarify our existing policy on density. Unless otherwise specifically stated, accessory dwelling units do not count towards the permitted density of a parcel. And on this slide, the definition of project approvals is proposed to be revised to specify that the term includes approval of both preliminary and final subdivision plans, and some very minor revisions on this slide, which just adjust some of the wording in the definition of lot coverage, but these aren't substantive changes. And that's 2513.
Thank you, sir. Sir, do we have any questions?
Yeah, a couple. Going back to one of the first slides, we're under purpose and goals. Paragraph D looks great. Paragraph E has some really interesting wording that I don't understand about equitable distribution of burdens and benefits. So who does that make liable for improvements that need to be made? See where I'm going with this?
Yeah, maybe a lawyer can explain that,
No, lawyer can't. Or who is liable if they make changes
yeah.
without permits?
Yeah, and what's the definition of equitable here?
If person A is approved to do something, does that mean that person B would be allowed to do something else if they argue that it would be equitable?
would defer to Ron on this, but I have go ahead first, and then I'll jump in wherever you need me.
The state has incorporated this jargon into COMAR, and we're unfortunately required to address it in terms of whether one individual would be given special or preferential treatment based on.
Ron, excuse me, can you identify yourself first?
Oh, I apologize. Ron Marney, Calvert County's environmental planning regulator.
Thanks, sir.
Regarding the question as to whether one individual would receive special or preferential treatment, no.
Okay. The other concern I have is when you look at something like equitable distribution, the relative liability for taxpayers versus private owners. I mean, what's the state's position on that regarding this language? Or is that clear?
As with many things, it is not.
Yeah.
And if I could just jump in here,
Yeah.
that's actually going forward, that'll be a new element under the adoption of comprehensive plans across the board. It's in legislation now.
Yeah.
So it's not just in critical areas, it's gonna come up in everything we do going forward.
That is accurate. This is a pushed change in Annapolis, and it is comprehensive across spectrum of what planning and zoning and a lot of other agencies would be expected to deal with.
And I think, I'm sorry, I hope I'm not cutting you off,
Yeah.
but we haven't gotten a lot of guidance from Annapolis yet on this. So the questions you're bringing up are questions that we've brought up as well.
Yeah.
That is accurate. We have asked for clarifications, but without clear direction from the state in terms of what they mean, and to ensure that that does not change, because sometimes guidance changes, not really possible to give you a solid answer on that one.
Until we know what it means and get further clarification from the state, is there any imperative to include the language in E right now?
Yes, because in the absence of doing that, this was a condition of them approving the critical area portion of our zoning ordinance that was just adopted.
All right.
There was there's a part of this language that we debated with the state, and we were concerned with as well. And
Right.
basically, we can't overrule the state.
Okay.
And Ron's kind of underneath Damocles' sword here, because if we don't go along, then they're going to pull permitting power from us.
Okay.
And then every time you wanted to build a deck, you'd have to go to
Okay.
up the road to get a permit. Good luck on that.
Is paragraph C exact vernacular and text from the state?
Yes, that is the exact language they gave
Verbatim.
to us. Verbatim.
Okay. Well,
So if somebody were to want to have equitable distribution of benefits of critical area, then they could argue that to the state that they should have free access to public beaches in the critical area, because that would be a benefit.
They can, but I'm not sure if that's within the
Yeah.
purview of DNR Critical Area
I'm just-
Commission. That's the problem with this type of jargon language.
Right. Ambiguous at
It's
best.
ambiguous, and it can mean a lot of different
Right.
things. I can tell you, the main concern for me is anyone going to be treated differently or unfairly in Calvert County under the law? The answer is emphatic no.
Right.
Regardless of who applies for a permit, the conditions are exactly the same.
Thank you.
All right. Any other questions or comments?
Yeah, there was one on, question I had, and you and I talked about this before, Ron. I'm trying to remember if it was on the record, or I think it was just a private conversation about whether revising the critical area maps every 10 years is adequate, or should it be, should it remain at 6 years? And the issue is the existing uncertainties with how quickly sea level rise and other climate effects might actually change what should be a critical area or not, and whether 6 or 10 years is adequate given scientific uncertainty.
Yeah, we did discuss this, and I would say that it is adequate. We're simply abiding by the state's required language. There's nothing stopping us from pursuing it outside of that 10-year time frame. That's just the minimum standards we'd be held to.
Okay, I just want to get that on the record. Thanks.
So if a storm wiped away Solomon's, we can redo at 5 years.
I mean, God forbid that happens, but yes.
Right, yes, thank you for adding that. I appreciate that, Ron. Very fond of Solomon's.
After the people are out.
Yes. Okay. So, we don't have an applicant, we don't have, all concluding comments are done? Concluding questions, gentlemen? No? Okay, public comment?
I don't have anyone in person to speak. If there's anyone online who wishes to speak on this particular topic, please use *6 to unmute. I have no one.
Okay, could we have a motion on action here?
I move that we close the record, find the proposed text amendment in TA 25-13 is consistent with the Calvert County Comprehensive Plan and recommend adoption by the Board of County Commissioners.
Thank you, sir. Would anyone like a second?
Second.
We have a second from Commissioner Williams. Any discussion or comments? All those in favor?
Aye.
Are there any against?
Yes.
Yes? So we have it at 6-1, and Mr. McQueen is the sole against. There you go. All righty then. That takes us to adjournment, correct?
Yes.
Would anyone like to make a motion?
Motion to adjourn.
Thank you, sir. Second. All those in favor?
Aye.
Aye. We will re-adjourn in 5 minutes.